Hi, John Riley from John Riley and Associates, coming to you once again on the Legal Strike Force channel. Today I'd like to continue our discussion of examinations under oath. This will be part 2 of a short series of these to help you better understand the process and what is involved in an examination under oath with an insurance company. Now, prior to sending examination under oath requests, insurance companies may already have done several things, such as taken a recorded interview of you, such as sending you what is called a proof of loss and asking that you sign, complete, and return that. Perhaps having another second recorded interview or statement taken from you by an adjuster. When you receive a notice for an examination under oath, one thing to remember is to get your paperwork together, and that includes asking for copies not only of transcripts but of the original recordings that you may have given before the examination under oath process is requested. This helps you to thoroughly prepare, and it helps prevent you from having inconsistencies in your statements, saying one thing at one time and another at a different time. That said, some companies resist giving that, and depending on the law of the jurisdiction in which you reside, this may have been decided by a court as to whether or not they're required to do so. If it is not, my argument would be that it's part of their duty of good faith and fair dealing to give you their recordings of you and the transcripts, not just the transcripts, because on many occasions we found them to be entirely filled with inaccurate statements, places where the person who transcribed it couldn't understand it and they just indicate inaudible, and yet it's right there on the transcript. Now, so that would be the first step. Then the second step would be to look at the notice. Now, notices can be deceptive. Usually they have to be reasonable as to the time in which they're requesting this to take place. In other words, there are court decisions saying that an insurance company can't request an examination under oath with a day or two's notice. So it must be a reasonable time frame, must be at a reasonable place. They can't require someone in one state to travel hundreds of miles to some other location. Usually this doesn't happen, but it would be grounds for refusing to do it unless they changed the arrangements. There will also be a request many times for documents attached to it, to the notice of examination under oath. The documents may seem to be very extensive and burdensome, and you might say, wow, they're really getting into my private situation here, my personal information and so forth. Why would they have a right to that? Well, depending on the type of claim, the insurance company may have the right to seek information of that type. You should, however, consult with an attorney in your jurisdiction if there is an extensive list and you have questions about any of the items that are being requested. But generally, things such as tax returns and past medical records and things of that nature are fair game for the insurance company to ask for as they try to assess your claim. Now you might ask, well, what if I'm ill or out of the country and I have vacation plans made and so forth? Well, that's okay, because the whole point here is that the insurance company must also be reasonable, and they need to accommodate your situation. So if you were having a surgery and going to be laid up for 3 or 4 weeks, or you had a pre-planned vacation, you would politely ask, either directly or through your attorney, that it be rescheduled on that grounds and on that basis. And it's good to document it from your end as well. That is, the insurance companies are keeping documentation of what is said between you and what writings and documents are being sent to you and received from you. So your documents should be pretty clear. You can send and write to them or email them and indicate why that this would be an inappropriate time, or that you need additional time to gather all the information that they've requested, which is another reasonable ground to have more time to prepare for your examination under oath. Sometimes, and I'm going to end on this thought, and we'll come back to the actual examination under oath itself, but sometimes we've found clients who have criminal charges pending against them or threatened against them and are asked to give an examination under oath. And you would think, well, gee, I have a right, a Fifth Amendment right not to speak at this time, and so forth. Or I want to wait till after the criminal charges are over. Generally speaking, you do not have the right under this contract to avoid an examination under oath because criminal activity or administrative actions of some sort are contemplated or ongoing at the time of the request. But if that is your situation, you should definitely be seeking legal advice as to how to proceed. Now, there are many more facets, obviously, to the examination under oath process. And in future presentations, we'll go into some of the questioning, how that goes, maybe some of the little ploys and things, I don't want to say tricks, but ploys or devices that are used and things that occur during examinations under oath that may be of assistance to our clients and to our listening audience faced with an examination under oath notice. Thank you. Have a good day, and remember, you can call our office if you have questions. If we can't help you, we'll refer you to someone who can. Thank you, and have a good day.